Showing on the program today, we discuss some issues arising from the recently concluded conference of the Nigerian Bar Association, NBA. My guest is the Vice Chairman of the Technical Committee on Conference Planning and former Chairman Section on Business Law, Judicial. Also showing on the program, a look at some of the provisions of the law under which government enforced measures to curb the COVID-19 pandemic and the move for a modern legislation, plus our weekly recap of the trending legal stories in the news. Hello and welcome to the program. I'm Shola Shieli. A lot of issues were thrown up at the recently concluded 60th conference of the Nigerian Bar Association. There was an urgent call by the presidency for judicial reforms, which the bar is supposed to champion. And this was the starting point of my conversation with Mr. Judicial. How can the bar help with achieving these much-needed reforms?
It is achievable.
How can we achieve it?
It is achievable. First of all, I think we must put our minds to the fact that the longer cases take to be decided, the more damage we do, not just to the reputation of the profession, but to the business environment. Reputation of the environment, of the profession, because we stand for the rule of law. And if criminals are detained and their trials take for so long, they are essentially denied justice. And as we know, everybody is presumed innocent until proven guilty. Now, what if in the end, the so-called criminal or accused is innocent? You would have done untold damage to him. Now, on the side of the business environment, you know, one of the attractions to business is the speedy resolution of disputes. And the longer it takes in Nigeria, the less attractive we are. And that is why, go and check all over the place. We always lose the argument whenever we are negotiating transactions and drafting whether Nigeria should be a seat. Yes, even if when we agree that Nigerian law is applicable, they would rather have the seat of resolution somewhere else. And it's an indictment on every one of us.
Because of the uncertainty of our time limits.
Absolutely. Now, in terms of how the primary question is it feasible? It is feasible in the sense that the lawyers, the judges, who are the key participants, must, at the pain of some kind of sanction, put their hands to the plow. Right now, there's too much indulgence of members of our profession who seek unnecessary adjournments, either because they're not ready or they are pursuing their whatever sanship ranks or whatever they are doing and all whatnot. The actual justice, which is the motive for going to court, it's lost. Then for the judges, those judges who in the first place are not up and doing will very much and readily and quickly hide under this sort of delay tactics. But at the pain of sanction is everything. Right now, there is a bit of it going on. For example, judges are required to submit a number of judgments over a period of time, and many judges, it forms part of the appraisal. So just increase the appraisal. And judges should then come down very hard on practitioners who then employ delay tactics. And if you need to amend any law to protect those judges, so be it. Once there is sanction, people will live up to what needs to be done. It can be done. It's just for us to resolve that it can be done. Now, on other platforms, arbitration, mediation, and all whatnot, it takes far shorter. In fact, what happens is that when you conclude an arbitration, for any reason it is appealed, then you have delay. We've earned this very unenviable reputation of having a judicial system that essentially hides wrongdoers. If you don't want to pay your rent, you go to court. If you don't want to honor a bank obligation, you go to court.
And store the cases
and just, yes, and
for as long as you want.
It's so notorious. And we have had issues of even trying to enforce foreign awards, foreign judgments in Nigeria. You know, it's speedily resolved there, and it comes there, and then 10 years later, you're still going back and forth. And we cannot relate those delays to how it hurts the economy. So the president was absolutely right. And it's a challenge to the entire profession. So the NBA has its work cut out. So at whatever levels we need to carry on this discussion, we must get to that point where we should aim to resolve criminal disputes within a year, civil disputes 15 months.
One other reason that has been fingered as a major contributory factor is the over-reliance on technicalities. Why does it appear like our courts cannot do away with technicalities like other jurisdictions, England, they've done?
You know, I have been so very vocal about how we have allowed form to take precedence over substance, even from the way we dress. All the places where we borrowed wig and gown, they just dumped it and moved on. So we tend to place unnecessary emphasis on appearances as opposed to doing what justice requires you to do. Anyway, for many of us, especially those of us who are involved in transactions, candidly speaking, we place so much emphasis on mediation, conciliation, even arbitration. You know, we will go to reluctantly accept it has to be done. Because what we now get clients to understand, that there is no dispute, no matter how complex, if on a give and take basis, you cannot resolve. And that should go on side by side with the justice system. But honestly speaking, something drastic needs to be done.
Another issue raised by the president at the conference was the issue of appointments and elevation of judicial officers. He suggested a merit-based approach. They should be made to write tests instead of this current system of progression, age, and date of appointment, and you just move on. What are your thoughts on that?
In fact, this issue of appointment is actually even tied to delay. Because what we've seen over the years, with the application of so many things we've imported into the judicial system, the quota system, federal character, blah, 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 merit has suffered. In those days, they actually begged successful practitioners to come to the bench, which is why it's called an elevation. They actually, because when you do that, you pack up whatever you're doing and you go. So it gives you the status. So when you know what you are doing, you will know the importance of time in relation to the dispensation of justice. But when now, today, the appointment process involves a lot of these things that I said, lobbying is what it is today. People actually lobby to become judges. People lobby for their own to be made judges. People lobby for elevation. Judges are faced with the indignity of lobbying non-judicial officers for promotions. They are forced to interact with politicians, the very things they should be insulated from because of the way we've carried it on. Yes, the president is unsung, but a lot of that blame is in the hands of the executive.
Oh.
Because the system of appointment, because the nominating authority is the NJC, but the appointing authority is the executive arm. And we know many times they trade off.
Oh, so you want me to confirm? That we should think out with the way...
Yes, there should be a system that keeps the judiciary in control of itself, the legal system to be control of itself.
So are you going to be recommending to the new leadership of the NBA to do something about sending a bill, maybe proposal to the National Assembly to look at the laws?
Absolutely. In fact, as you are aware, the NBA works through its sections, and one of them is SPIDA, the section on public interest and all that. They are the ones who would now begin to take up all these hiccups, because some legislations already exist. You really need to just go there and create the amendments. And if we discuss amongst ourselves, we get NEC approval and everything, we should go fight it. Happily, many legislators are lawyers. So we can lobby our colleagues. As long as what we're doing is altruistic and it is going to move the system forward, I'm sure we can get yes, I'm sure we can get their concurrence. Because it's not enough to sit back, do all the kind of criticisms that we are doing now, and then we do nothing about it. We need to take them there.
I like what you say about, the NBA coming together and, pushing for some of these reforms. And so this brings me to my next question, because the unity of the bar is one of the issues that has hogged the headlines, in the past week. And it also dominated the conference because there were agitations about some speakers and, issues of unity. And now we're hearing talks about a parallel bar. So my question is, what do you think that the new leadership should be doing to bring the bar together so that we can collectively, push for reforms on some of these things that you've talked about?
Well, any discerning leadership should always listen to all the component parts of the association. We cannot bring about value judgments about whether the person is right or is wrong. There is some discontent, deal with it. And I'm glad that the Apata administration has started with consultations with the, well, they call them the northern groups, but honestly speaking, there are issues there, but he's done the right thing. It's called the leadership there, and they've given him their unflinching support for United Bar. If it is every time you disagree, you want to form a new association, the bar will be broken into 200 bars by now, and everything. So we must,
and it won't help.
It won't. We'll weaken ourselves, and these issues we're discussing will continue to fester. So the elections were a source of worry. He's also pledged to look at it and everything. But I think all of us agree that the results of this election largely reflected the will of the people.
Majority.
Of the majority. So I just urge everybody who has not been happy with the outcome to still work within the system that's provided. Come together and let's move forward. We've pledged for reforms. We can't go back on electronic voting because, let's face it, if we get it right at the bar, we can export it to the center, because we must get to that point where we're able to manage numbers. And this electronic voting has helped.
One of the high points of the conference was the swearing in of the new administration.
Yeah.
And by the way, congrats to you, because I recall that you nominated, or is it, you nominated Oluwapasa for president.
I did,
congratulations.
Yes. My pleasure.
So the rest, they say, is history. In his inaugural address, the 30th president of the bar called for a special recognition scheme under which lawyers who can show concrete evidence of public interest advocacy are considered for elevation to the rank of SAN.
Yeah.
Do you share this view?
Absolutely. I mean, ask anybody. They begin to tell you that the system, again, the same thing we're discussing. Something starts out with a good intention, but then in this application, it gets corrupted along the way. Many people have criticized this whole sound shape thing, not because the fundamental reason for wanting to recognize excellence is not a good idea, but when you then begin to wonder why is it limited to some category of lawyers, and then you just don't recognize all the others, it loses its value. And yes, like with everything else, it's time to take a step backward and begin to say, hey, who are those who are actually contributing to the growth of this profession? In other climes, the Privileges Committee actually has members of the public, because these ranks, these elevations are more for the benefit of the public than the individual. Whatever, it is a privilege when you're a lawyer. It's a privilege to serve your society. It's not just there for you to go and feather your nest. It is to make sure that those who are voiceless, those who are oppressed, and those who don't have hope, look at you and know that, look, all hope is not lost. We must keep that hope alive.
Welcome back. Let's move on now to issues of the global pandemic COVID-19 and some of the provisions of the law under which government enforced measures to curb the pandemic, and also the move for a modern legislation. Quarantine, like labor issues, are said to be exclusive matters under the 1999 Nigerian Constitution. And a look at the only legislation with provisions to tackle a pandemic, the Quarantine Act of 1926, shows that it gives the president the authority to make laws. This has, however, not stopped some states, like Lagos and Rivers, from enacting some legislations to fill perceived fundamental gaps created by the law. Section 5 of the Act stipulates a 6-month jail term or a fine of 200 naira for contravening any of the regulations made under the Act. It vests the magistrate courts with jurisdiction to commence and determine proceedings for imposing any fine or imprisonment. Because it was passed at a time when air travel was not very popular, the Quarantine Act of 1926 makes no provision for the prevention of infectious diseases through air travels, and this has been identified as one of the shortcomings of the Act. The Act also did not provide for the requirement and training of medical and health workers or their remuneration, or at least a compensation scheme for those whose lives may be lost in the process.
The Act is very clear that it is targeted at treatment of persons who are suspected to suffer from one infectious disease or the other. There is nothing in the Act addressing those who are not suffering from infectious diseases. So you cannot use that Act to declare, for instance, a lockdown. And that was why we took up the precedent as of March 29, when he declared a nationwide lockdown. And of course, you recall that the governor of Lagos State also purported to make a regulation directing how people should move. And indeed, some people have been put to trial erroneously, as I believe, under such regulations.
Also, issue of the fact that even under our constitution, the Quarantine Act is under exclusive jurisdiction of the federal government, going by the 1999 constitution. But we discovered that some of the state government and even the local government had to make some regulations and others under the current pandemic that broke out. In other words, taking the act itself to out of the exclusively that was reserved for the federal government. So there are some things that had happened even under the current dispensation that the act itself may not be able to meet up with the current reality.
Perhaps to bring the law up to date with modern times, a bill, Control of Infectious Disease 2020, was introduced by the Speaker of the House of Representatives, Honorable Femi Gbajabiamila. The bill aims to further strengthen Nigeria's public health institutes, the Nigerian Center for Disease Control (NCDC's) mandate, and clarify the manner of declaring a public health emergency. Among other things, the bill provides for a penalty of between 200,000 naira and 5 million naira, as well as jail terms for violators of its provisions. Although many critics acknowledge the deficiencies of the Quarantine Act of 1926, they however insist that the new bill is draconian. Provisions such as Section 8, which takes away the duty of confidentiality owed patients by their personal physicians, Section 30, which allows for forceful vaccination, and Section 70 of the bill, which ousts the jurisdiction of the court and protects the DG and his health officers from personal liability, have been flagged for their potential to violate personal liberty and privacy, and for disregard of the federal structure of the country and the principle of checks and balances.
The new bill will address some of these fundamental issues and allow whoever is clearly supposed to be in charge of actually executing or any order or making regulation, or even though people are arguing that the powers given to the DG of the control disease body is so much and so unlimited.
There is a particular section which says that if the Director General restricts your movement, seizes your property, and you want to have any complaint or grievance against that, you make an appeal to the minister. The concern here is that once you make that appeal to the minister, the determination or decision of the minister in respect of your appeal is final, which means the court cannot query it. I cannot imagine in this time of our national life for us to be raising monsters and dictators.
Going forward,
There's clearly a need for more consultation on the provisions of the proposed legislation. This would make the bill have more acceptance and legitimacy amongst the people.
And just before we go, here's a recap of some other legal stories we're tracking.
We begin with the report that the Supreme Court has upheld the election of Governor Yahaya Bello of Kogi State. A 7-man panel of the court, led by the Chief Justice of Nigeria, Justice Tanko Mohammed, reached the decision in 2 judgments, dismissing the appeals filed by the People's Democratic Party and the Socialist Democratic Party. The judgment upheld the validity of the November 16, 2019 governorship election in the state. The PDP and the SDP, along with their governorship candidates in the election, had alleged that the poll was marred by corrupt practices and non-compliance with the provisions of the Constitution, the Electoral Act, and the Independent National Electoral Commission's electoral guidelines. But the Apex Court dismissed the appeals on the grounds that all the allegations were not proved by the appellants. In the suit challenging the qualification of Sagize Iyamo as the governorship candidate of the All Progressives Congress APC in the September 19 governorship election in the Edo State, Justice Taiwo has recused himself. Justice Taiwo, a judge of the Federal High Court Abuja, withdrew from the case following a petition filed against him by one of the lawyers in the APC team. The judge described as disturbing what he called the wicked and unsubstantiated petition designed to question his integrity and maliciously tarnish his image. According to the judge, it's not only coronavirus that has become a pandemic. A speed at which politicians write petitions against judges should be declared a pandemic and checked. He said it was unfortunate that judges could not respond to petitions against him through the media. He, however, maintained that he had no affiliations, personal or political, with any of the parties in the case. The 22-year-old musician, Yahaya Sharif Aminu, who was sentenced to death for allegedly blaspheming Prophet Muhammad, has filed a case of no appeal before Kano State High Court. Sharif Aminu, who was sentenced to death by an upper Sharia court on August 10, 2020, has described Sharia law as practiced in the state unconstitutional and undemocratic. The Kano State Judiciary said it has submitted certified copies of the Sharia court judgment to the human rights activist Femi Falana, Senior Advocate of Nigeria, to enable him to appeal the judgment. The Nigerian Bar Association has also sent a fact-finding team to Kano State. The leadership of the judiciary has asked state governors to replicate the gesture of the Rivers State government, who built houses for the judges in the state. The Chief Justice of Nigeria, Justice Tanko Mohammed, represented by a Justice of the Supreme Court, Justice Mary Odili, commissioned the judges' quarters in Port Harcourt on Thursday. Justice Odili thanked Governor Nyesom Wike for building the estate and naming it after a late Senior Advocate of Nigeria, Chinwe Aguma. According to her, the nation's judiciary deserves more than it is currently getting, and time to change the unpalatable narrative has come. Governor Wike said the commissioning of the judge's apartment is in fulfillment of the promise made by his administration in 2015. Mr. Wike explained that the move is necessary to improve on the living conditions of judges who contribute to the dispensation of justice in the state. And for the bar, leaders and branch chairmen of the Nigerian Bar Association in the Northern Geopolitical Zone have dissociated themselves from any splinter group of the association, including the new Nigeria Bar Association, NNBA, and resolved to work with the new leadership of the NBA led by Olumide Akpata. They gave the assurance after a meeting in Abuja with the national leaders of the NBA, during which Akpata pledged to work for the unity and progress of the association. The meeting was attended by 40 branch chairmen and leaders of the NBA from the Northern Geopolitical Zone, who urged all lawyers to support the new leadership so as to ensure that it delivers on all its core mandate while putting the rule of law, the welfare and capacity development of members at the forefront. And outside Nigeria, a British court has granted the Nigerian government more time to appeal against the $9.6 billion arbitral award delivered in favor of a British Virgin Island firm, Process and Industrial Development. Nigeria had applied to the court for an extension of the time to appeal against the award, having earlier missed the initial 28-day deadline.
And here's where we adjourn till next week. Don't forget that you can watch again this episode of the program and past episodes on our YouTube channel. I'm Shola Shieli. Thank you for watching.